Welcome to Employment Law This Week. I'm George Whipple. Given the pace of change in the first weeks of President Trump's administration, it can be difficult for employers to keep up. Today, we discuss the implications of two important actions that reverse decades-old precedents. When the administration announced the immediate firing of a member of the NLRB and two EEOC commissioners, the unprecedented moves triggered a great deal of confusion, but they also set the stage for a series of court battles. We asked Epstein Becker Green's Erin Schaefer about the fallout from the firing of NLRB board member Gwen Wilcox.
President Trump is really calling the question here by firing board member Wilcox, a question that many have been asking since the middle of the Biden administration. There have been persistent challenges to sections of the National Labor Relations Act that prevent the president from removing administrative law judges or board members. And so while those questions previously were hypothetical, now that President Trump has taken this action, those questions are front and center. So we expect litigation over these issues that are already underway to take on an increased urgency. And we expect there to be new litigation challenging the president's authority to remove the board member.
After member Wilcox's dismissal, the five-member NLRB is left with only two sitting members, which means the board doesn't have a quorum. We asked Erin how employers should respond to the developments in the near term.
This story is developing daily. Guidance is coming out daily. And so the first is to keep your ear to the ground. The second is when you're dealing with the National Labor Relations Board, whether it's responding to investigations or in litigation, making sure that you're preserving your arguments and arguments about the constitutionality of the board, arguments about the quorum issue and raising those things now to preserve them for the future. And lastly, if you have an issue or a decision pending before the board, because the board doesn't have a quorum right now, the board will not be issuing decisions. So if you are waiting for something, it's going to take longer until that third board member, fourth board member is appointed and approved by Congress.
On Saturday, February 1st, the NLRB issued a statement that indicates the agency intends to continue to do virtually everything other than issue board decisions through the Office of the General Counsel. We anticipate further challenges to this. And in his first week in office, President Trump also rescinded Executive Order 11246, first issued in 1965. This action effectively ended affirmative action programs for federal contractors and grant recipients. Epstein Becker Green's Courtney McFate fills us in on what that means for the Office of Federal Contract Compliance Programs.
The new executive order requires that every federal contractor and grant recipient certify they won't operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. This is a really significant representation to be required of all contractors and grantees. Now that there are no affirmative action program obligations, and the OFCCP and other federal agencies have been ordered to cease and desist all investigative and enforcement activity under the revoked Executive Order 11246. It's really unclear now what the scope of OFCCP's authority is, but most likely it is only a matter of time before the OFCCP is eliminated. The affirmative action provisions of the Rehabilitation Act and the Vietnam-era Veterans Readjustment Assistance Act, or VEVRA, neither of which are addressed in President Trump's executive order or Executive Order 11246, presumptively remain in effect. However, the affirmative action obligations under those laws are quite different, and they're much less robust than they were under Executive Order 11246. And employers that are state and municipal contractors may still have some affirmative action obligations under their contracts with those governments. Title VII is still the law of the land, and it requires that all qualified candidates have equal opportunities for employment.
Thanks, Erin and Courtney, and thank you very much for watching. We'll see you next time.